Welcome everyone. I'm excited to begin this brand new lecture series on JIGL, that is Jurisprudence, Interpretation and General Laws, a core paper in the CS Executive Program, Group 1. Today we begin our discussion with Chapter 1, Sources of Law. For ease of understanding, I have divided this chapter into three sections. Section 1 focuses on jurisprudence, where we will be going to the foundation of legal thinking. In section 2, we will dive into the schools of law, examining different approaches to interpreting legal systems. And in the section 3, we will uncover the sources of law, where laws originate and then how they gain legitimacy and authority. So let's begin our journey into the world of legal thought, starting with the very roots of jurisprudence. Today we are diving into a section 1, jurisprudence, which lays the foundation for understanding the legal thinking. In this session, we will explore what is jurisprudence and then what is legal theory. And in the next video, we will go through who are the key thinkers and their contribution in shaping the jurisprudence. So this chapter sets the stage for everything that follows in your legal journey. Let's go through the meaning of jurisprudence. Jurisprudence is derived from Latin word juris means law, and then prudentia, which means scale. So Latin word is jurisprudentia, where juris stands for law and prudentia stands for legal or a skill or a knowledge. So if we put together, we will come to know that jurisprudence is a knowledge of law. It is a systematic study of law, its nature, purpose and principles. Okay, some people also say that this is a grammar of a law. This is the grammar of a law. Okay, so let us go through few definitions here to understand what exactly the jurisprudence is. Key definitions. One is E.W. Patterson. He explained that jurisprudence, he defined jurisprudence as a body of ordered knowledge which deals with a particular species of law. There are two elements in this. One is it is a body of ordered knowledge, means it is a systematic study. It is nothing, it is not a random study or something. It is a systematic study of study of what? Study of specific branches of a law. Say there are many branches within a law. So like maybe a commercial law or a criminology, etc. Studying the nature, scope, everything of a specific species of a law is called as jurisprudence. Then Levelin's definition, jurisprudence means an empirical study of events and factors that influence the judge. Okay, the important aspect here is this is an empirical study, means again it is a systematic and a scientific study based on direct observations and experience. It is not a belief alone or it is a random study or something. It is a scientific study. Moving on, we will see some other definitions here. Let's now look at how John Austin shaped the understanding of jurisprudence. Austin proposed the jurisprudence should focus on positive law. Okay, the Austin's major focus is on positive law, that is law as it exists, studying of a law as it exists. Okay, there is no need of studying law which is ought to be. Okay, it is all studying law what it is exactly, that what it should be, that is not a subject matter of law. Further, he emphasized that the command of sovereign as the core of legal authority. So in the first line itself we can see here Austin proposed jurisprudence as the study of positive law, concentrating on the command of a sovereign. Command of a sovereign means laws are the command given by a sovereign or a government authorities. According to him, jurisprudence is not about morality or ethics, but it is a systematic study of actual laws enforced by governing bodies like government authorities. Okay, in India, who makes the law? It is a parliament. So So whatever the laws given by the commanding authority or a government authority, that should be studied as it is. That is a law. Further, Austin divides jurisprudence into two categories. One is general jurisprudence and the second one is particular jurisprudence. General jurisprudence and particular jurisprudence. General jurisprudence deals with universal legal principles common across all legal systems. Okay, like basic principles, concepts, and ideas of a law. Whereas particular jurisprudence focuses on how laws operate in a specific societies. For example, how contract law operates in India. Okay, so that's the example for particular jurisprudence. However, Austin's classification faced a lot of criticism. People said it is impractical to classify legal into two studies, general and particular jurisprudence. Further, they also criticized that it limits the scope of jurisprudence by ignoring moral and societal dimensions, because Austin's more focus is on laws or commands of a sovereign. So there is no question of morality and other things, right? So people questioned on that also, or criticized on that point. So one more definition. Now let's contrast this with other thinkers. Salmond expanded the idea of saying jurisprudence includes legal principles that guide the society. So he offered two senses to a law. One is general sense, where jurisprudence as the science of civil law, and in a specific sense he said jurisprudence as the study of fundamental principles of civil law. So the most common thing between both the senses, it is a civil law. It focuses on civil law. So he narrows down the scope of jurisprudence to a study of civil law. So that was heavily criticized by other experts. And finally, Ulpian, a Roman jurist, believed jurisprudence is the knowledge of what is just and what is unjust. His view brings a morality and fairness. What is good for people, what is not good for people. So it brings in morality and fairness in shaping the study of jurisprudence. It is a thought process of a Roman law, and Ulpian is one of the key promoter of that. So as you can see, jurisprudence has evolved through different lenses. We will go through main key contributors, definitions, and their viewpoint on law and jurisprudence in the later stage, like in the third video or next videos, we will see that. Let's now look at a more holistic and philosophical view of the jurisprudence as explained by Justice P.B. Mukherjee. Okay, he described jurisprudence as both an intellectual and idealistic abstraction and also a behavioral study of a man in society. So he broadened the scope of jurisprudence. He said clearly it is a both intellectual and idealistic abstraction, as well it also study of behavior. It is also a behavioral study of man in the society, which also includes social, economic and cultural ideas. So he made that it is going to be a multidisciplinary subject, jurisprudence, because it includes political, social, economic and cultural ideas. So that's why it is a multidisciplinary field. So P.B. Mukherjee's view helps us clearly distinguishing between law and jurisprudence. Is law and jurisprudence both are same? No. Law is the set of rules, whatever we follow. But jurisprudence is the philosophy beyond those rules. Note that law is a set of rules given by sovereign authority or whatever we follow, customs, other things. But jurisprudence is the philosophy behind those rules. It doesn't aim to create a new laws, but it reflects on the existing ones. The purpose of jurisprudence is to study the fundamental legal principles that shape the legal systems. So it is not a rule. The jurisprudence is not a law. Okay. The fundamental purpose of jurisprudence is to study the legal principles that shape the legal system. It's a functional and conceptual study asking questions like why do we have laws? What values do they present? How do they evolve? So in terms of nature, jurisprudence is a multidisciplinary because it takes care of social, political, ethical, and all other factors. It is a open-ended and it is not fixed. It keeps adopting, changing environment, and it is a ever-growing. As society changes, so does our understanding of law also get changed. So jurisprudence is multidisciplinary, open-ended, and keep growing. Let's see now understand why jurisprudence is not just an academic subject, but a cornerstone of the entire legal system. Two key benefits two important importance of jurisprudence are: one is fundamental role in legal system, and the second one is on a legal practice and education. Jurisprudence plays a fundamental role in shaping legal system. It provides the intellectual foundation upon which laws are built, interpreted, and applied. Whether it is a legislation or a judicial decision making, jurisprudence ensures that a structured and principled approach to the justice. It is often said that jurisprudence is the art of law. Just like a grammar is to language, jurisprudence is for law. Without it, legal system would lack the coherence and depth. Its impact goes beyond theory. In legal education, jurisprudence guide how law schools design their curriculum, helping future lawyers understand the why behind the what. In legal practice, it equips lawyers with the tools for logical analysis, enabling them to interpret law more effectively and efficiently and argue cases with a greater precision. For legislators, jurisprudence ensures the correct use of legal terminologies while drafting laws, avoiding ambiguity and confusion. In short, jurisprudence is what gives law its soul and structure. It's not just about rules, it's about reasoning, justice, and the value that hold society together. Moving to our next important topic for today's video is meaning of a legal theory. As we saw, jurisprudence is all about systematic study. Uh, W. Friedman in 1945 introduced the term legal theory. Legal theory as a term was first coined and used by W. Friedman in 1945. This marked a turning point in jurisprudential thought, introducing a more structured way to analyze the foundation of a law. Legal theory is a distinct intellectual field within jurisprudence. It is not a separate, it is not an independent thing or something. It is within the jurisprudence, a distinct intellectual field. While they are closely related, they serve different purposes. Jurisprudence broadly examines the nature and structure of law, whereas legal theory dives deeper into the philosophical underpinnings, asking not just what law is, but why it exists, how it should evolve. All those important things will be answered in legal theory. Importantly, legal theory doesn't arise in vacuum. It is a byproduct of a philosophy, religion, ethics, and politics. Okay, so as we saw earlier, jurisprudence, many authors or many experts believe that it is studying law as it is, right? But legal theory brings in, it covers law as it is plus philosophy, religion, ethics, etc. It is a legal theory is a byproduct of all this. These disciplines shape our understanding of justice, authority, and morality, all of which are embedded in the legal system. So, as Friedman emphasized, the task of legal theory is the clarification of a legal values and postulates up to their ultimate philosophical foundation. In other words, It's about peeling back the layers of a legal norms to reveal the deeper principles that justify them. So legal theory can be studied in two parts. One is a positive theory and the another one is a normative theory. Positive theory focuses on describing what the law is, its structure, sources and operations. Normative theory, on the other hand, evaluates what the law ought to be, engaging with the moral and ethical questions. Okay, two parts. Positive theory focuses on what law is as is, and here normative theory, law what ought to be. Let's see these two theories in detail. Positive theory of a legal theory, which is often referred as a legal positivism. This theory asserts that law is a set of rules and norms created by social institutions such as legislatures and courts. Who creates the law? Legislatures with the parliament or assembly, they create a law, and then also sometimes the court also gives some decisions and that will be considered as law. So this theory, positive theory, asserts that the law is a set of rules and norms created by a social institution such as legislatures and courts. Crucially, it emphasizes that validity of law is independent of moral and ethical consideration. Okay, the law positivism, again clearly I am saying, it studies as it is. It will not consider any moral and ethical consideration. So as long as it is enacted by a legislature, then we need to read as it is. Legal positivism focuses on what is rather than what ought to be, what it should be, right? So it is concerned with the structure, sources and enforcement of law. The good examples is the statutory law systems in a country. So in India, we have a law which is created by legislatures like Indian Contract Act, Indian Income Tax Act, Indian. Okay, so those all are examples of a legal theory, or sorry, positive theory. So it is reading law as it is, which is given by legislatures or court. Now, unlike positive theory, which focuses only on a positive theory, which focuses only on law, what it is, the normative theory is concerned with what the law ought to be. It brings in moral and ethical dimensions, asking whether existing laws are good, just, fair, and aligned with the societal values. So whatever law is passed by legislatures, it is a questioning that whether it has a moral value in it, whether it has a ethical dimensions in it, is it a just, fair? All these things can be studied as part of a normative theory. So normative theory does not just describe law, it evaluates and critiques it. It challenges the legal frameworks and encourages reform. If there is no morality and if there is no equity and in those aspects, then it will ask for reform in those laws. But where is this normal theory will be used? Normal theory plays a vital role in shaping the debates around justice, equality and legislative change. For example, it's a central to discussions on civil liberties, anti-discrimination law, constitutional amendments, etc. When any debates and other thing happens, so the aspect of normative theory will come into picture. The last topic of this video is the difference between legal theory and jurisprudence. As I initially said, legal theory is part of jurisprudence. Jurisprudence is a more wider or a broader concept. Jurisprudence is the philosophical study of law itself. It asks fundamental questions like what is law, why does it exist, and how does it relate to a society, morality, and politics. It is a deeply interdisciplinary and drawing it from history, culture, and ethical and political theories. On the other hand, legal theory is more focused and structured. It is more focused and structured, legal theory. It deals with the legal concepts and systems in an organized way, aiming to clarify the nature, purpose, and functions of the law. It is essentially a subset of jurisprudence, offering a framework to explain and understand legal ideas more precisely. In terms of scope, jurisprudence is wide. It includes various schools of thought, natural law, legal positivism, sociological jurisprudence, etc. We will see all the schools of law in a later part. Legal theory is a narrower, often concentrating on specific theories, especially like Austin's command theory, where it says that laws are commands given by sovereign. Okay. Jurisprudence connects with disciplines like history, politics, and philosophy, whereas legal theory tends to stay within the realm of abstract legal reasoning. Finally, in terms of methods, jurisprudence helps us understand the full nature of the law and justice, even if it is not directly applied in legal practice. Legal theory, meanwhile, is more practical in studying the core meaning of legal concept, often using examples, case studies, and logical analysis. So while jurisprudence gives us the big picture, legal theory zooms in to sharpen our understanding of specific legal ideas. Okay. Once again, I am repeating this. Jurisprudence gives us the big picture, whereas legal theory zooms into a sharpen our understanding of a specific legal ideas. So that's bring to an end of this lecture. So I'm concluding this video. In the next video, we will dive into the key contributors in the field of jurisprudence, the thinkers whose ideas have shaped the legal philosophy across generations. If you found this helpful, please subscribe to the channel and don't forget to share it with your friends and classmates who might benefit from this content. Thank you so much for watching. Let's meet again in the next video. Thank you.